Welcome. This is the Candlewood Point Homeowners Group second video. This video is intended to answer the question, what was the effect of the error that the town made in the appraisal of the land values of 13 properties in the Candlewood Point community? It's important that you have seen and understood the first video where we've gone through the analysis of what error occurred, how did it likely occur, and then the position of the homeowners group that this error was not fully addressed. And the question many of you have asked is, well, what was the effect of that error? What are we talking about in terms of dollars and cents? So what we've done is we've added a page here, computing this really quickly, to the Excel spreadsheet that went through the analysis of the error, which we've shown you before. And we call this new tab the overtax amount. So again, you can obtain this spreadsheet by contacting us at the CP Homeowners Group at gmail.com. That's CP Homeowners Group spelled out at gmail.com. What we've done is we've taken the 13 properties. So this is 2 Lake Point Drive, 3 Lake Point Drive, 6 Lake Point Drive, etc. Again, there's 13 properties. We've taken the assessed land value, and again, this issue relates strictly just to the assessment of the land value for 2015 and 2010. We don't have information for prior years, but we do make an estimate as to what the amount of real estate tax collected was. And then we show how much tax was collected as a result of using an incorrect neighborhood factor. That is the neighborhood factor that should have been assigned to Candlewood Point, and it's assigned to all the other Candlewood Point lakefront properties is 1.25. Instead, the town used 1.6. So we took the difference of the effect between 1.6 and 1.25. And for example, here I'll take a property number 2. This property paid $2,757 more in real estate tax for the 2017 fiscal year. And again, that's 2016-2017 fiscal year as a result of using an improperly high factor. So it's pretty straightforward. These numbers are several $1,000s, between $2,500 and $3,000. Some of these properties are water view properties. That's why their tax rate is substantially lower. These are the figures for the overtax amount as a result of locating these properties in the incorrect neighborhood. Again, originally the town had been assessing these properties as if they were part of Candlewood Trails, and in fact that was wrong. They were not part of Candlewood Trails, or part of Candlewood Point. Candlewood Point has different valuation metrics in our view. So this was the amount of the overtax for the 2017 town fiscal year based on the grand list of 2015. And again, we've computed it for all the prior years. We've taken the actual millage rate for the last 10 years and laid that out as well. And to compute the overtax amount for the 2 prior 10-year periods, what we've done is we've looked at the increase in the real estate tax is averaged 3.9% on compound annual growth rate for the last 10 years, ending in the 2017 fiscal year. So 3.9% compound annual growth rate. This is twice the rate of inflation. It's probably 3 times what you could have gotten in a bank account. And it covers a period when real estate taxes were adversely affected for most properties during the Great Recession, which ran from 2008 through to probably 2014, 2015. So it's a pretty significant growth in the property tax level. As you see, the millage rate went from 21.34 10 years ago to 26.77, and then for the current year, it's going to pop up again to 27.5. the millage rate has, in fact, been growing probably most substantially, really, in the last in the last 6 years, excuse me. So anyway, we take a 3.9% growth rate and we apply it backwards, and we can compute the amount of overtax. And so what we've done is we've added up that overtax amount for the last 10-year period, for the last 20-year period, and for the last 30-year period, and again for each of the properties. So here, for example, number 20, this property paid $23,000 more in real estate tax based on its land assessment in the last 10 years than it would have paid if the town had properly assigned the neighborhood factor of 1.25. So we added up, it's 232, rounding 233,000 for the last 10 years, 395,000 over the last 20 years, and 484,000 over the last 30 years or so. And again, we've asked the town for how long this error has been occurring in the system, and they've refused to answer the question. So this is the analysis of how much the overtax amount has cost these residents. So now I guess some of you have gone on to ask the question, well, what does this mean now? And it means, and ask, well, what can the group do? Or what can the individual homeowners do? And the answer, sadly, is not much that is likely to be effective. In this story, there are two types of characters. There's the sheep and there's the shearers. And the shearers have the strength of law behind them in the sense that the state of Connecticut prescribes a process for real estate evaluations where the communities assign through a mass appraisal process real estate values, and they're assigning market values and assessed values. Assessed values equal 70% of the market value, and they can use whatever methodology they want. They can be as careful as they want. They can be as careless as they want. And there's really no recourse for homeowners if they are not. Connecticut law does require that towns set up an appeal process, and many homeowners have taken advantage of that. Many homeowners have similarly found that the appeals process results in nothing happening. The town is under no obligation whatsoever to listen or consider an appeal or to act on it. They're free to do whatever they like. And if that occurs, then the homeowner really only has one option. Connecticut law requires that if they are not satisfied in their appeal, they have to bring a case in Connecticut Superior Court. And that's the only recourse they have. There's nothing else that they can possibly do. And if they do that, the homeowner is looking at having to hire an attorney, though it's not required, but it is recommended, having to hire an attorney. And furthermore, then the process requires that the homeowner submit a appraisal given by a licensed appraiser. Now, a licensed appraiser who would produce a report and then testify in court is going to charge several $1,000s for that. And then the homeowner in the town does the same thing. That is, they go to presumably an appraiser that they've got a good relationship with and a good history with and do business with. Pick that appraiser, and that appraiser will do an appraisal on the property. Then the homeowner has to go out of pocket for their legal expense and their appraisal expense, and again, that's several $1,000s. Both of those then go to the judge. The judge reviews the two appraisals and then chooses. Now, you might ask, well, what about the mass appraisal? What has that got to do with any of this? And the answer is nothing. That is, the town takes the first stab at the appraisal process, and you can appeal it if you think there's an error. But the error itself is not a part of the trial. It's not a part of the valuation determination. It's not a part of the outcome. So the town, again, can do whatever it wants, generate a figure and send you a tax bill. If you don't like it, you can appeal it. But the appeal process will have nothing to do with what the history of the calculation of the original appraisal by the town was. That is all that's, I guess, water under the bridge. So again, town can do whatever it wants, can listen to you complain, choose to do nothing. Your only recourse is to hire an attorney, pay for an appraisal out of pocket, none of which is reimbursable. And you go to that expense just to show the town that they made an error. Now, you might ask, well, the house right next to mine just sold at half of its appraisal value. Why can't I argue that in court? Well, you can't. You have to hire a licensed appraiser who will do that. You're going to have to find one that doesn't have a conflict of interest with the town and will generate a fair appraisal. But that appraisal is going to be considered against the client-friendly appraisal that the town has submitted to the court as well. So in this scenario, the sheep really don't have a lot of recourse, really anything to do, because the town, having made an error, is under no obligation to correct it. It, in fact, was under, apparently, and has been explained by 2 judges and several attorneys to members of our group, that the town can do what it wants. It can do it as indifferently as it wants. In fact, it's under no good faith obligation whatsoever. But the recourse option really is solely based on a suit brought in Connecticut Superior Court, where the plaintiff and the defendant submit their appraisal, appraisers testify, and then the judge chooses which appraisal was correct. So, anything other than spending several $1,000s is not an option, apparently, for homeowners. So anyway, that's the conclusion of the story. Again, these are the figures that are associated to the incorrect valuation in the view of this group. So again, the sheep really don't have a lot to say if they feel the shearer hasn't done the proper job. And perhaps the final comment on this, the only thing the sheep can really do is to make it clear what's happened, what's going on, and really rely on sunshine as being the most powerful antiseptic here, and hopefully ensure that things like this don't happen again in the future. Thank you.